The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the submission of 3 cases. The case of Borst Brothers versus Finance of America and others is hereby submitted without oral argument. And we will start this afternoon's oral arguments with the case of DeSousa versus Iowa Realty. It's my understanding Ms. Hermanson will be arguing for the appellant. Is that correct? Yes, ma'am. Thank you. You may begin.
Thank you. Haley Hermanson on behalf of Appellant Iowa Realty. May it please the court. In this premises liability action, the district court held that Iowa Realty owed a duty as a possessor of land that it did not own, occupy, maintain, possess, or control. The denial of summary judgment on this basis constitutes a radical departure from long-standing Iowa law predicating liability on control of the land. Here, Iowa Realty's only connection to the property was the fact that an Iowa Realty agent listed the house for sale. The threshold issue in any negligence action, and the sole issue on this appeal, is the existence of a duty, a question of law. Duty as a land possessor hinges on 2 things: occupancy and control of the land. And this court has consistently required that a party have substantial control before imposing liability. Yet there are no facts in the record suggesting that Iowa Realty had or exercised any control over the Finnerts' land. That alone should be dispositive of this appeal.
If Iowa Realty had held an open house at that house, would they have had sufficient control?
Well, I think that presents a different scenario, and I think consistent with the restatement 3rd, you would analyze the duty there under the principles articulated in Section 7. But again,
That get you with respect to control. If the issue here is control, does an open house by a realtor in, obviously it's a hypothetical, but in a similar situation where the homeowner has vacated the house, they've hired a listing realtor, and now the realtor is holding an open house at the house, is that sufficient control?
I think you would have to look at the facts of that particular case. I think the scope note to Chapter 9 in 3rd restatement makes clear that a non-possessory actor on the land, you would analyze a duty there under Section 7. So I think, to answer your question, no, I don't think that that would be sufficient control to impose a land possessor's duty. I think you would analyze the existence of a duty under general tort principles. And if the actor created a risk of harm, then that would give rise to a duty.
Well, if it was an open house with one prospective purchaser.
Just so I understand your question, you're saying it's an open house, but only one prospective purchaser comes. I don't really think that that would impact the duty analysis, no.
Today's real estate market.
I want to make sure I understand. In this case at issue, the realtor who was actually showing the house at the time is not the same. Is that correct? As who it was listed with?
So the plaintiff contacted her own agent, a buyer's agent not affiliated with Iowa Realty, and requested a private showing of the premises, and met her own agent on site less than 24 hours later.
So, what these questions maybe are getting to is this isn't it might be a different case if there had been an Iowa Realty agent on site at the time that Ms. DeSousa or Ms. Johnson was injured. Is that correct?
I think any facts suggesting any additional control would present a different case, because here all you have is the listing agreement.
Hypothetically, if we ruled against Iowa Realty and recognized a duty, anytime you're merely a listing agent, even if you're not there, how would life change? What bad consequences would flow?
Well, first, you would be imposing the duty of a land possessor, and that's a duty well beyond just clearing snow and ice. That extends to all risks arising from the land. It includes a duty to inspect and discover, as comments E and F to Section 51 make clear. There's no easy limiting principles, I don't think. I think it would be very difficult to cabin the scope of that duty to just snow and ice. And I think trying to impose limiting principles would result in arbitrary line drawing and perpetuate the problem that this court and the restatement third sought to avoid by adopting a uniform reasonable care standard and abolishing the common law distinctions.
Possible for land to have no possessor? I mean, supposing ownership of the land is in person A, but person A is nowhere to be found.
Suppose it's possible. I don't think that's the case that we have here. What you have here is the Finnerts admitted that they owned, maintained, and controlled the property on the date of the date of the injury.
They said, although query, it seemed, at least in part, a legal conclusion. If the owner of the property is not exercising control, and you can contest that in this case, but I'm pursuing the hypothetical. If the owner of the property is not exercising control, and the real estate agent has the authority to enter the premises, does the real estate agent have any duty then? The real estate agent a default possessor? I'm kind of exploring a little bit.
So, comment C to Section 49 in the third restatement articulates pretty clear guidance for determining the party in control, and that's the person who both has the authority and the ability to take precautionary measures. And only the Finnerts had that here. The record evidence establishes that they were, in fact, taking steps to discharge that duty.
Again, right, we're, maybe not dealing with the facts of this case, but what if the Finnerts had said to the Iowa Realty agent, well, why don't you, we don't live there anymore, so before you show the house, would you be sure to make sure that the driveway is clear and the pathways to the house are clear? What if that had happened?
I agree that could present a different scenario, but again, that's not the facts that we have here. Mr. Finnert testified that anytime there was snow and ice, he would pack up his snowblower and shovels and drive over to the house on Parkview Drive to clear the snow and ice. And there's been no allegation in this case that there was an assumption of the duty or a course of dealing. This case proceeded solely on a premises liability theory, and that's accurately reflected in the record.
What are other courts doing? Where's the weight of authority in other jurisdictions on this issue?
Weight of authority is that most courts have declined to impose a duty on realtors out of public policy concerns, and there's been universal rejection for any duty of care on buyer's agents. The courts that have found listing agents can owe a duty have done so in limited circumstances, and often relied on prospective purchasers' status as invitees in reaching that conclusion.
Could the agent, in this case, the Iowa Realty agent, have said no to the buyer's agent in terms of going on premises?
Evidence in the record that Iowa Realty or its agent was even notified of this showing, so I don't think he would have had the opportunity.
Seemed like, I think that the realtor that did show it made mention in a text that she had to get access or approval or something. What kind, does she have to get approval from Iowa Realty?
So it's That's not in the record, but I think amicus referenced it in their briefs. There's online applications that sellers and their agents can utilize to allow buyers and their agents to request showings.
But expect that if you're the listing agent, not anyone, not just anyone could go in and look at the house that you've got listed there. So there's a process, but it's an entirely online process.
My understanding, and the lock boxes allow licensed realtors to be able to enter the property.
And so why should we not follow those jurisdictions that have recognized at least some limited context in which realtors could be liable when they're the ones that are controlling, like in the context of an open house?
Sure. We don't have that here, and so if this court were to recognize that duty, it wouldn't be on the facts of this case. This case is solely a listing agreement, yes. Sure.
Mine should be, and so it'd be helpful to kind of to push back against why, you are in a different space, but so you're also saying, well, we shouldn't even recognize it if there's an open house where they do have control. So I'm just asking what the policy reason is behind that.
Well, the reason that we impose a duty on land possessors, and this court has reiterated it several times, is it's the party with the ability and the authority, the party that is best in the position to identify risk and to be able to take steps to reduce the risk of harm. I don't know if a realtor, even in an open house scenario, is the best party to do that.
Well, and Justice Appel's hypothetical of, say the owner moved to Italy, and so they left their house under contract with a listing agent to sell it, someone needs to have some authority. And so if the homeowner is out of the country, and kind of going back to the someone needs to be in control, as between someone who you're inviting to come to the house to buy it, why should that liability fall on them as opposed to the realtor?
Well, I think the law has always placed that burden squarely on the property squarely on the shoulders of the property owners. And if you knew you were moving out of the country, I guess you would expect the property owner to make arrangements for that. And maybe the listing agency does provide property management services. I mean, the parties are certainly free to contract for those types of things. But I think that you would expect the property owner in that situation to be able to make those arrangements. Recognizing the duty urged by the plaintiff in this case would impose the burdens of property ownership without the corresponding benefit. And in fact, there is little benefit to be gained by recognizing such a duty at all.
Really, he's going to have to get a little more insurance, that's all. Isn't that all? Isn't that what we're really talking about here? Who's going to insure against the loss?
Well, I don't think that that's quite the question. There's not a gap here or need to spread the risk. The homeowners already insure against the loss. The plaintiff already has recourse, and she's asserted a claim to that effect. But the property owners were the only people who were even aware that they had a duty and could insure against that type of eventuality.
At the trial of this case, if the only claim is against the property owner, what if the owner says, well, again, I'm not saying this necessarily here, I live far away. I told the listing agent I wouldn't be able to take care of the property. I told them that they were, responsible, and I didn't even know there was ice and snow on the driveway. And on that basis, I should not be found negligent. And what if, and then the plaintiff ends up with no defendant that it can pursue a claim against. What if that's the scenario?
Well, again, I think you would have to look at the particular facts of that scenario. I'm sure that the outcome could be different if the parties had come to a different agreement as to who was responsible for those types of duties.
Was there any evidence in the record that this particular Iowa Realty agent removed snow and ice in other listings?
No, Your Honor, there's no evidence in the record of that. This case really is as simple as it seems. Iowa Realty did not occupy or control the property, and it therefore owed no duty of care.
The district court relied on Section 7 and said, under Thompson, we removed the idea of foreseeability, and so there is at least a jury could find that the owner was not aware that there could be snow and ice, but the realtor could have been. So where is it that the district court messed up then?
Well, I think, first of all, the district court erred in finding that a reasonable jury could find that a duty existed, being that that is a legal determination, not a question for the finder of fact. Second, perhaps you found more clarity in the order denying summary judgment than I did, but it wasn't entirely clear to me the basis for the denial.
Well,
So is it your position that we don't go to the general Section 7 analysis, we go to the landowner provisions, the ones you quoted earlier here, because it's a premises liability claim? Is that what you're saying? Section 49.
Yes, I think that first, this case was a premises liability theory solely. That was the only theory alleged. The petition, paragraph 13, cites failure to warn and remedy a hazardous condition. That was how plaintiff chose to pursue this case. So yes, I think in particular here, we're talking about a land possessor's duty. But as the restatement makes clear in the scope note, for a non-possessory actor on the land, you would just analyze that under the general principles articulated in Section 7.
Thank you. May it please the court. What we have here is a very narrow ruling in Judge Hefner's April 2021 order, where he allowed the case to move forward against Iowa Realty. And we have an effort here to say that his ruling is now expanding the scope of a potential duty on a real estate agent to create a risk of harm to the economy at large, and that there's no way that Mr. Gotch at Iowa Realty could have known that something would need to be done for people coming onto the property who are arranging visits to the property he's listed solely through, and the only evidence in the record, which we have from Mr. Finnert's deposition, is that these visits were arranged by Iowa Realty. They had no control over those visits.
Counsel, I know that Mr. Finnert says that sort of at the start, that he thought maybe Mr. Gotch was going to be removing snow, but I thought later in his testimony he kind of walks that back, doesn't he?
And I appreciate the question. I don't think he walks it back so much as he concedes that if snow had accumulated, obviously I'm not living there, but I tried to make my way over there to remove that from the property when I had an opportunity. I think what he says on the other hand is that I don't know when these showings are taking place. So, that's not known to me ahead of time. So if someone has scheduled a showing with Iowa Realty and there's snow and ice on the property, it's not necessarily the case that I'm gonna have that removed by the time that person gets there, which is exactly what happened here. So I think that's the distinction that Mr. Finnert's making in his deposition testimony is, yes, I was going back over the property. I don't live in Italy. I'm living here in town. So I am removing snow on occasion, but I don't know when these showings are taking place.
Maybe I'm wrong about this. I thought he said that if Mr. Gotch is not the one doing this showing, then Mr. Finnert thought that he was the one that needed to remove snow. Am I wrong about that?
I mean, my recollection of his deposition testimony, which is the only sworn testimony we have in the entire record, is that he understood that if he recognized there was winter weather, he would address that when he had the opportunity to address it. But on the other hand, because he wasn't forewarned of showings, he assumed that something like that, snow or ice, if someone's going to see the property, only Iowa Realty would be aware of that. So for snow and ice to be cleared ahead of that showing, only Iowa Realty would be able to remedy that issue. I mean, he would have no ability to do so. I think that's, again, all we have is one deposition in this entire case, because this appeal happened at a very early stage. Almost no discovery had been conducted. I think Judge Hefner wanted at least the homeowner's deposition to be taken before he made a final ruling. That was submitted into the record, and he made his decision.
I mean, duty is a question of law, and it really doesn't turn on foreseeability or not. We got rid of that aspect of it, correct?
Foreseeability, I think the question is, did the actor's conduct create a risk of harm? I think that's the question that needs to be asked.
Premises liability, in other words, if your theory is that this is land and it was an unsafe, or premises and it was an unsafe condition, then aren't you then under Section 49?
I think the analysis is, first, did they exercise requisite control of the property, substantial control of the property, which I think is a factual question. I think Judge Hefner ruled that. His basis is that the homeowners did not know when showings would take place. They would have no forewarning of any visits to the property. So beyond that, he thinks it's a factual issue. Perhaps Iowa Realty was exercising substantial enough control to, okay, if they're an occupier, possessor of land.
All right, so you have that fact that Iowa Realty would schedule visits without the homeowner's knowledge. Any other facts that show that Iowa Realty controlled the property? I mean, is there any other sense in which they controlled it?
Right, the sense in which they controlled the property is that a buyer's agent or potential buyers of the property, in order to access the property, that permission could only be granted by Iowa Realty.
And I can't find it in the record, maybe there's not one, you're talking about a scant record. If, and this is just based on my own experience, which is not great, but if, let's say that the realtor's fee is 6% and it's listed with company A. If company B actually shows the house, do they share that 6%, 3 each? I'm just wondering, does Iowa Realty have a dog in the fight if that second person would have had a successful sale? Don't they make money off of it?
Split the fee, although that's not my expertise and that's not evidence of the record. But yes, I think that's how it works between buyers and sellers agents.
Policy matter, you've got a cause of action against the homeowner for premises liability. Why do you need to add other parties?
And Judge Hefner discusses this in his April 2021 order, is that unlike a lot of cases like this, and there's a lot of premises liability cases in our district courts, the Finnerts weren't present on the property. So I think when we were analyzing the case and the facts, well, they're not there. Who's actually responsible for making sure? I mean, it's not my clients. They don't know anything about the property. Who's responsible for making sure that a hazardous condition is removed from, ice and snow is removed from the driveway and the walk? So it came down to, well, if all showings are conducted through Iowa Realty, they need to be added as potentially a responsible party, the same as the homeowners. And I think it was brought up earlier, if they're removed from the case, that doesn't stop the Finnerts from testifying just the way they've testified previously, which is that I had no idea. This was my real estate agent's job. I had no conception of when there would be a showing. I thought that he was going to handle that. So you have them making this allegation against Iowa Realty in a jury trial, but Iowa Realty is not in the case.
Yeah, and the counter is, well, you lived 7 miles away. You knew that the snow had fallen, and obviously it had fallen in you too. You knew you have your home up for sale. You know that people are coming to look at it. Why didn't you get over there and clear the driveway?
Accurate. I mean, he obviously did have a sense, Mr. Finnert did have a sense that he needed to get over there and remove snow when he had the opportunity. I think the issue is that he's not in a position to know when people are entering onto the property. You know, is his job to, the instant there's any accumulation of ice and snow, is to leave the current property and go to the Parkview property? I don't know,
That might be a negligence claim. I have some concern that it seems like you've pled a premises liability claim, which will turn on control. Did you plead negligence?
I mean, failure to warn, failure to remedy a hazardous condition is premised in negligence.
Section 7 is going to control the general negligence claim. And it's not a premises liability claim. It's a risk of harm problem. And you're stating, I guess, that the risk of harm, your client affected the risk of harm because your client was in a position to know when a potential buyer would be on the premises. Is that the sum and substance of your argument, or do you have more?
I think the substance of my argument is that Iowa Realty creates a risk of harm when they know people are visiting the property, which that's information they would have exclusive control over. Mr. Finnert would have no control over that information. And then a hazardous condition exists on the property and is not remedied.
In this record about whether the Finnerts asked to be notified about when people would be brought on? In other words, give me an hour so I can get over there and clear snow? Did they ask?
That was not a topic that was touched on. It was, as I summarized earlier, essentially, I was making an effort to get over there when I could to clear snow and ice, given that it was December in Iowa, but I didn't know when showings were occurring. So he kind of, there's no evidence in the record of any sort of explicit discussion between Iowa Realty and Mr. Finnert on that topic.
Record about time periods when people would not be coming over. In other words, we're not going to have people over on Mondays or Sundays or for this week. Or was it sort of generally known that people might be coming at any time?
Was it known by the Finnerts? There's no evidence in his deposition on that topic about whether certain days were off limits or not. Now, what we have in the record is that they were not living there. They had vacated the property, were living elsewhere in the Des Moines metropolitan area.
If we may, I'm sorry if I cut you off. Go ahead. Yeah. Let's talk about case law. And let me just share with you what I found, and maybe you found more. But I didn't find much current. I found older cases. I found 3 or 4 states, I'll call them open house cases, where a real estate agent was exposed to liability. I found one case, I think, out of California, but this was a case where a realtor actually did the showing. I mean, was physically there and did the showing. I did not find any cases where an absent real estate agent was found to be liable for conditions on the premises. I will admit, all these cases strike me as pre-restatement third, and might fall in a different box then. But bottom line is, in my search for authority for the proposition that you advance, I didn't find any. I don't think you did either.
And candidly, no, or else that case would have been discussed. I think these are unique facts, which is why Judge Hefner's ruling is quite narrow and explicitly recognizes that, look, the Finnerts aren't present on the property, and that's why I'm ruling the way that I'm ruling.
Seller's agent has a duty, in your view. What about the buyer's agent, especially if they're splitting a fee? And in this case, the buyer's agent is present.
Buyer's agents have almost universally been excluded from having a duty like this imposed on them. You know, I do think that you have to look at, I mean, who's in the best position to alleviate the risk.
There. They were there. They got there first, right? They were there meeting Ms. DeSousa or Ms. Johnston, right?
But I think that, anytime people are being invited onto a property, those people could obviously show up when the possessor or the occupier of land is not there. I don't think we then transfer the responsibility to make safe the property to those people. Instead, we would say, these people, by your invitation, are being permitted to come on the property. There's a general duty to alleviate any risks that have been created. And the risk of harm here is falling on snow and ice that's accumulated.
Doesn't it seem 1 degree further removed to go after Iowa Realty? I mean, you're saying that the homeowners weren't there, and then the buyer's agents were the ones that were actually physically there, and you didn't think that was right. But then to go after Iowa Realty is even 1 more degree further removed, isn't it?
It's a degree further removed. I appreciate the question. I don't think it's a degree further removed because they have exclusive, and that's all we have in the record, they have exclusive control of the ability of people to enter upon these premises. Certainly not an ability that my clients have or the buyer's agent has in these circumstances. That's a power that, on the record we have in front of us.
Control, doesn't that mean that if I go out of town, like to my apartment in Italy, thank you, Justice Oxley, and I leave my keys with somebody and say, if anytime somebody needs to get into the apartment for anything, you can open it up for them. Do they then take on that liability, just like Iowa Realty in this case?
I think those facts are somewhat distinct in the absence of any sort of agreement between the parties. I mean, there's a listing agreement between the FinArts and Iowa Realty that Iowa Realty is going to show, on their behalf, going to show the property in an attempt to sell it to potential buyers. You have a business relationship here between those two parties. In your case, you have, I think, kind of a casual personal relationship between one person and another.
You're dealing with the same basic fact to show control. That is the ability to schedule people to come on and off the property. That's your basic fact showing control, right?
The ability to enter upon these premises was, on the record we have in front of us, exclusively the province of Iowa Realty. And I've
Last week for a family wedding, and we hired a house sitter. Should I have warned her, by the way, if there's a snowstorm and somebody slips and falls, you could be sued too? I mean, they're in control. I left them in control of my house. They have the keys and the access. How is that different?
It would be, I guess, what we need to know in that situation is that person aware of other people being permitted on the property when they're coming, and what remedy would need to be taken. In your hypothetical, I don't quite know, but in this actual,
Read it online, but let's say I still have a paper delivery in the morning, and the house sitter knows that somebody's going to be walking by to drop off the paper, and they're going to walk up the sidewalk.
to the extent she could be considered an occupier, controller of land,
She's staying there overnight as opposed to a listing agent that is remote.
Sure, I think that I'm over time. May I finish?
Well, that's okay. Even if you want to stop.
The listing agent is in a different position in that anybody who wants to access this property goes through them, given the situation at hand, that the property is vacant, that they're the one showing the property, that any knowledge of anyone entering onto the property would be in their possession, okay, not in the possession of somebody else. So I think that's our perspective and why we think that this appeal should fail. Thank you.
Thank you. Justice McDermott, I'd like to answer the question that you posed. Yes, Mr. Finner did later go on in his deposition to clarify that specifically as it relates to the factual scenario presented in this case, that if another agent was showing the property, he understood it to be his responsibility to go over and clear the snow and ice. And that's on appendix page 108. And on appendix page 107, he clarifies that he was never aware of a circumstance in which his Iowa Realty agent cleared snow and ice from the property.
On this issue of you had to have the Iowa Realty agent's consent to go on the property. I mean, you heard the argument, the other side's relying upon that as a factor increasing the risk of harm under Restatement 7.
There aren't any facts in the record that support Mr. Glaser's position. Mr. Finner didn't have any personal knowledge as to how or the process by which buyer's agents could request showings. And I suppose that gets to a little bit more of the heart of the matter is there are no facts in the record that could create a genuine dispute of fact. In fact, the plaintiff did not cite to any record evidence in resisting summary judgment. It wasn't even until the supplemental briefing that he submitted any evidence at all.
Say, though, that the buyer had to request permission. So maybe the listing agent didn't know, but Iowa Realty as a company, who was also, I think, sued is a defendant in this action, it was their website that the buyer's agent would have gone to request permission. Is that right?
This is not in the record, but based on the amicus brief, it's a...
From the realtor to Ms. DeSousa that said, I've gotten, I'll set up an appointment. Okay, I got the appointment. So that at least infers that she's getting permission from someone, presumably Iowa Realty.
My understanding is it was a third-party website.
Well, let me ask you this, though. If it were true that Iowa Realty permission was required, I know you say it hasn't been asserted, the record may be unclear, but if that were true, Iowa Realty would be in the position of permitting access to the property or denying it. By permitting access to the property when there's snow and ice, the risk increased. So if that were the fact pattern, if there was, in fact, kind of a permission, a gatekeeping function by Iowa Realty, then under Section 7, there probably would be a general duty, wouldn't there?
Here, the risk resulted from natural conditions as opposed to any conduct by Iowa Realty, or even in your hypothetical, the realtor's scenario, the realtor's conduct wouldn't have created the risk of harm, giving rise to the plaintiff's injury.
Community, I mean, I don't live in one, but if you did, I mean, you always have to get permission to go in there. Does that mean the person at the door, the homeowner association or whatever, creates a risk every time they let somebody in?
I suppose so, if that's the case.
In determining what the law is, if the restatement has a general provision, but also more specific provisions on premises liability or owner-occupier liability, wouldn't we look to the more specific and with those control over the general?
If there was any evidence to suggest control here, and then substantial control, as this court is required to impose a land possessor's liability.
Back to what I had asked earlier, I can't imagine Iowa Realty would ever give permission for that place to be shown if they didn't have a pinch of that coming out if it gets sold. So isn't that different than the cat example, babysitting a cat and stuff? I mean, isn't there an understanding with realtors? If you're going to let someone else see it, you're going to get a cut of the pay that they might receive?
I can't speak to that specifically, but I imagine so. But I'd also like to point out that realtors provide purely intangible services, the marketing and sales of a home. That's very different than a contractor who's actually going to physically change the land. That's the job he's hired to do.
And say, you really should clean all that crap out of that room and you should move your couch. And there's more than just intangibles, aren't there, when there's a relationship?
Those are at best suggestions, though. I don't think that I think it's one thing for the realtor to say, hey, your wall should be painted white. That would really help your house sell, versus coming in with a paint can and starting to paint the walls themselves. It's ultimately up to the homeowners whether or not to make any changes. May I conclude briefly? In short, as I said before, this case really is as simple as it seems. Iowa Realty did not occupy or control the property and therefore owed no duty of care. We would ask that this court uphold the longstanding control principle and reverse the denial of summary judgment. Thank you.
Iowa Realty is hereby submitted, and we'll have a brief pause here while we get ready for the next case, State of Iowa versus Miller.